Still morning. Good morning, all of you. I was of the impression that the training program that we were having today would be participated by the entire officers and staff of the High Court, because some of the topics that are there in session 2 is interdepartmental coordination, file tracking system, so on and so forth. र यसको लागि खाली जुडिशियल सेक्सन मात्रै भन्दाखेरि मलाई पनि अलिकति म पनि छक्कै परे बिहान है र but what we'll try to do is we'll try and understand what is interdepartmental coordination and the other topics that has been assigned to me, right? सरले भन्नुभएको जस्तो फाइल जब बनिनु लागि त कहाँबाट बनिन्छ, सेक्सनको सबैभन्दा तल कार्डरबाट बनिएर त्यहाँदेखि हाईएस्ट लेभलमा स्याङ्सनको लागि पुगिन्छ नि त हैन। सो फाइल ट्र्याकिङ गर्दाखेरि यो फाइल बनाउँदा के हुन्छ त भन्दाखेरि एउटा सेक्सनबाट बनायो या त एउटा अफिसरले बनायो, अर्को अफिसरले राखिदिन्छ, एक दिन दुई दिन या एक हप्ता, कोही बेला 10-15 दिन। अनि what happens is there is no responsibility and no accountability to be fixed who has actually kept the file. कोही बेला what happens is sometimes there are important files for judicial section. There are some compliance to be given to the honorable bench. Sometimes there are compliance letters as well as affidavits to be filed before the honorable Supreme Court, and these are files which are very, very important, and it has to start from your section and it has to go right up to the Registrar General, who takes the approval of the honorable Chief Justice, and then an affidavit can be filed before the honorable Supreme Court on time. But it so happens, perhaps rarely, but it happens, that's my experience, that the file gets lost sometimes. Sometimes the one section would say that we have never received this file. The other will say that no, I have kept it actually 2 days, but how come it is 2 weeks now? I cannot comprehend this. र कतिवटा के हुन्थ्यो भन्दाखेरि पहिला अब आफूले त पठायो आफ्नो सिनियरलाई हैन, या त रेजिस्ट्रारको अफिसमा, रेजिस्ट्रार जेनरलको अफिसमा तपाईले हिजोको तारिक 29 तारिक 29 अगस्त 2025 मा तपाईले साइन गरेर पठाइदियो फाइल अप्रुभलको लागि। फर्केर आइन्छ 2 हप्ता बाद, 2 हप्ता बादमा फर्केर आउँदाखेरि सिग्नेचर चाहिँ छ 29 अगस्त 2025 को हैन, र त्यहाँदेखि गाली खानुपर्छ त्यो फलना जसले पठाइन् उले, र तिमीलाई त त्यही दिन पठाएको रहेछ फाइल, तिमीले किन राख्यो भनेर नि। So in order to streamline all these, what the computer section has done of the Honorable High Court, I'm indebted, I'm very thankful to the computer section. त्यहाँ रमेश हुनुहुन्थ्यो हैन, त्यहाँ के भन्छ ओपी, सागर, तेन्जिङ, and there's one more person, I forgot his name, Mr. Sharma हैन, यहाँ श्याम पनि हुनुहुन्थ्यो त्यति बेला हो। र उहाँले एउटा फाइल ट्र्याकिङ सिस्टम नै हाम्रो लागि बनाइदिएको थियो, which I found very, very useful है। र I'm told, I do not know, but I'm told that you have stopped using this tracking system, but I urge you, please use it, because you will be able to fix responsibility, you will be able to fix accountability. त्यो गर्दाखेरि के हुन्छ भन्दाखेरि जसले गल्ती गरेको हुन्छ उसलाई पक्रिन सकिन्छ नि त, र जसले गल्ती नै गरेको छैन उसलाई त्यसै पनि कोही बेला त्यसै गाली खान्छ, त्यसै उसले सो कज पाइन्छ, र त्यसै सेक्सन भित्र नै साथीभाइ र दाजुभाइ हरूको बीचमा मिसअन्डरस्ट्यान्डिङ र झगडाहरू नहोस् भनेर नि त। र तपाईहरु देख्नुहुँदैछ हैन, यो फाइल ट्र्याकिङ सिस्टममा तपाईहरुको this is a login page. Once you log in with your username of your choice and a password, then your user ID is created. Once a user ID is created, you can open this, and then there is this dashboard. देख्नुहुँदैछ या is it too small? हैन, it is something like this. See, number of files that are in your office, number of files that has gone from your section, from your desk, from your system. So everything will be recorded, and you can have a sort of a chart here. तपाईको कति दिनदेखि कति समयदेखि यो फाइल्सहरु तपाईको डेस्कमा बसिरहेको छ भनेर नि त। र this is the interface. This is how you create a file. Let me make it a little bigger. This is how you create a file. यसमा तपाईले आफ्नो फाइल हेर्नुस् त, फाइल नम्बर लगाउनुहोस्, फाइल नेम लगाउनुहोस्, सब्जेक्ट, डिस्क्रिप्सन र प्रायोरिटी, अर्जेन्ट छ कि छैन हैन। अर्जेन्टको बेलामा त्यो ब्लिङ्क पनि गरिन्छ तपाईको त्यहाँ आएन भने नि टाइममा। र once you do this, तपाईको यो इनबक्समा आज खोल्दाखेरि देखिन्छ कतिवटा फाइल छ भनेर नि त। तपाईले फाइल कतिवटा पठाइसकेको छ, कतिवटा क्रिएट गरेको छ र सकिसकेपछि कतिवटा फाइल क्लोज हुन्छ भनेर। र these are, I think, very important if you can use it. How you track your file? ट्र्याक गर्दाखेरि अहिले कहाँ छ त तपाईको फाइल भन्ने पनि नि, from let's say from the UDA has created that file, र त्यो फाइल डेस्कबाट तपाईहरुको let's say मिस दर्शनाकोमा गएको छ, मिस दर्शनाले त्यहाँदेखि हाम्रो हेड अफ योर सेक्सन यहाँ जोइन्ट सरकोमा पठाइदिएको छ। उहाँको अफिस त अहिले एउटै तपाईहरुको एउटै उइसमा त छैन नि त हैन, you have different buildings altogether. So it becomes a little difficult for you to go and ask again and again. तपाईहरुको आफ्नो भित्र काम चलिरहेको हुन्छ हैन, it takes about 10-15 minutes to go there, come back again. So you lose that focus. कोही बेला के हुन्छ भन्दा you just want त्यो फाइल कहाँ छ त, what is the stage भन्यो भने sometimes you call up, मान्छे हुँदैन, so you just open your system, र त्यति बेला you can track कि मेरो फाइल चाहिँ फन्नाकोमा छ भनेर नि। Then you can also see in this software itself र फाइलको मुभमेन्ट चाहिँ कहाँदेखि कहाँ हुँदैछ भनेर नि। र I'm just giving you an overview, all right? This is not teaching, but just an overview. Many of you have already used it. Some of you may not have seen it, but I urge you, please take a moment and try to not only understand, but use it after you go back to your offices. This is the inbox. इनबक्समा तपाईहरुको यहाँ हेर्नुस् न, यहाँ उहाँले के लगाइदिएको छ भने क्लक पनि लगाइदिएको छ हैन। र this will give you an assessment of when it was created, when it comes हैन। त्यहाँदेखि तपाईहरुको send files, कतिवटा फाइल तपाईहरुले पठाएको, डिस्क्रिप्सन सबै छ। Once you give the description, the file number, it will be very easy to track these movement. तपाईहरुको फाइल क्रिएट गर्दाखेरि this is how you can do it. And I mean, I will not read it, but you can just have a look at this. र तपाईहरुको once your file is over, once the file comes back to you, once the purpose is served, then what you can do is you can close this file, right? What I want is not to have this kind of sort of a monologue, but let us try to have a dialogue. तपाईहरुको यहाँ कतिजना त हामी सँगै काम पनि त गरेको छौं हैन। म रेजिस्ट्रार जुडिशियल हुँदाखेरि पनि त हामी त्यहाँ काम गर्छौं। र I have always said that the judicial section is the heart of the High Court. है तपाईहरु कतिजना पहिला हामीसँगै काम गरेको छौ भने perhaps you must have heard me saying this, that the judicial section is the heart of the High Court. भन्नु मतलब के हो त? भन्नुहोस् त? What is the meaning of this? हैन? Why only seniors? तपाईहरु भन्नुहोस् न त पछाडी को हुनुहुन्छ? Are there some newcomers as well? नयाँ को हुनुहुन्छ? हात रेज गर्नुहोस् त? Okay, quite a lot. So, can you introduce yourselves, madam? पुरानो त म सबैलाई चिन्छु है. Yeah, no formalities. Please be relaxed and this. Yes, sir.
My name is Bhutia, and I am recently working as a reader of court number 3.
Court number 3.
And I was appointed in year 2024.
What did you say your name was, madam?
So Sonu.
Sonu Anma. All right, Miss Sonu. Nice to meet you. Yes, ma'am.
So my name is Chazil.
Chazil.
So I work in the judicial section.
Okay.
So I work as a data entry.
Data entry operator. All right, ma'am. Good. Yes. Who else? Yes. Yes, sir. What is your name? Sorry? Panzer Bhutia. What is your designation there, sir? You are an LDA cum typist. And you, sir, madam? Sorry, you are? Translator. You translate documents to which language? From English to Nepali? Okay, good. Lepcha language, very good. Yes. Nepali language, okay. Yes. In Bhutia language, okay. Great, yeah. Yes. The Limbu language, great, yeah. Yes, at the back, कोही हुनुहुन्छ? Okay. अरु त सबै चिनेकै छ हैन? So, what do I mean when I say that judicial section is the heart of the High Court? भन्नु मतलब चाहिँ के हो भन्दाखेरि नि मैले के भन्नु खोजेको भन्दा हाई कोर्टमा केसै छैन भने कोर्टमा केसै छैन भने त त्यो हाई कोर्टको त मतलबै भएन नि त. हाई कोर्ट इज देयर बिकज देयर आर केसेस र त्यो केस म्यान गर्नु त्यो केसलाई ह्यान्डल गर्नु लागि देयर इज वान पर्टिकुलर सेक्सन, a specialized section. अरूहरू त छ नि त. That is for other management. किनभने हाई कोर्टको फङ्सन अपार्ट फ्रम जुडिसियल देयर आर अदर्स अल्सो हैन. कतिवटा डिस्ट्रिक्ट कोर्ट्सको छ काम, कतिवटा फलनाको कामहरू छ र यो अरू एजेन्सिजहरूले पनि मेन्टेन गर्छ. तर जुडिसियल सेक्सन चाहिँ किन हार्ट हुन्छ भन्दाखेरि कोर्टमा केसै छैन भने त्यो हाई कोर्टलाई कोर्टै भनिँदैन नि त. त्यो त एउटा कुनै अफिसै हुन्छ नि त. So it is very important that the High Court should have a robust judicial section. जहाँ चाहिँ तपाईहरुलाई not only officers and staff, you should have good number of officers and staff. जहाँ चाहिँ तपाईहरुलाई maximum support त्यहाँ दिनु पर्यो. पहिला पनि त हामीले ज्यादा सपोर्ट कहाँ दिन्थ्यो त भन्दाखेरि the maximum staff was in the judicial section. अहिले पनि त्यही होला तपाईहरुको हैन. किनभने तपाईहरुको त्यहीबाट काम भएन भने एभ्रिथिङ विल गो रङ. मान्छेहरु फाइलिङको लागि आउँछ, कहाँबाट फाइलिङको लागि आउँछ हैन त. र फाइलिङ सेक्सन पनि हाम्रो तल्लोपट्टि थियो, निकै अप्ठ्यारो नै थियो. त्यसको बादमा पछि माथि एन्ट्रेन्समै जहाँ चाहिँ अहिले ई कोर्टको एउटा सेवा केन्द्र बनेको छ. That also acts as a filing section now, which is I think it has made it quite easy. Accessibility को लागि पनि त सजिलो भयो नि त मान्छेहरुको लागि. र from there it goes to the scrutiny section. ब्याक ह्यान्डमा पहिला यहाँ कमल सर बसेर उहाँले नै हरेक पन्नाहरू गर्नुहुन्थ्यो. र what I have experienced is that to work in a judicial section it's a tedious job. हरेक पन्ना चेक गर्नुपर्छ हैन त. एक जनाको काम हुन्छ त्यसमा. कतिजनाले पन्ना चेक गर्छ, कतिजनाले त्यसको मार्किङ गरिन्छ, कतिजनाले त्यो लेजिबल छ कि छैन त्यो चेक गर्नुपर्छ हो। र त्यसको बादमा फाइनली वेन इट कम्स टु रेजिस्ट्रेसन एन्ड देन इट गोज टु दि कोर्ट, र कोर्टमा पुग्दाखेरि चाहिँ अब इट हेज टु बी 100% प्रपर। त्यसमा केही गल्ती देख्नु भएन नि त, होइन त। र कोही बेला हुन्छ गल्ती, र त्यो सुधारेको पनि मैले जुडिसियल सेक्सनबाट देखेको छु। र त्यही कारण मैले भनेको कि जुडिसियल सेक्सन इज वान अफ द इम्पोर्टेन्ट सेक्सन, र हार्ट अफ द हाई कोर्ट भनेर नि। यहाँ हाम्रो एनजी सरले कुरा गर्नुहुँदै थियो कि वाइ डोन्ट यु हेभ एन एसओपी भनेर नि। आई थिङ्क द्याट्स अ भेरी गुड सजेसन, वाइ डोन्ट यु हेभ एन एसओपी भनेर नि। किनभने हाम्रो म जब रेजिस्ट्रार जुडिसियल हुँदाखेरि आई स द्याट देयर वर लट अफ कम्प्लेन्ट्स, अहिले पनि त हुन्छ फ्रम दि लयर्स, यो भएन त्यो भएन यो भएन। सम आर जेन्युन, सम आर जस्ट इट इज जस्ट फर द सेक अफ मेकिङ अ कम्प्लेन्ट। कसैलाई मन परेन अरे, कसैलाई के गरेन अरे, दे जस्ट पास कमेन्ट्स एन्ड मेक कम्प्लेन्ट्स, बट देयर आर जेन्युन कम्प्लेन्ट्स एज वेल। हामीले फाइल गऱ्यौँ, त्यहाँबाट त्यसै स्क्रुटनीमा हामीलाई रिजेक्ट गरिदियो, र यो डिफेक्ट भनेर निकालिदियो, विच इज एक्चुली नट डिफेक्ट एट अल। समटाइम्स वेन आई एनालाइज इट आई फाउन्ड द्याट ठिकै हो कुरा त, देयर वाज नो डिफेक्ट। समटाइम्स यस देयर आर डिफेक्ट्स, सो यु हेभ टु सी अल दिस एन्ड चेक यर रुल्स, होइन, एकताल कम्पेयर गर्नुहोस्। सो यु विल हेभ टु रेक्टिफाई, अदरवाइज विल नट बी एबल टु रेजिस्टर भनेर नि। एन्ड देन एक दिन हामीले के गर्यौँ भन्दाखेरि अनरेबल जस्टिस भास्कर राज प्रधान साहबलाई पनि we requested him, please sir, because you have a rich experience and quite a long experience as a member of the bar. One point of time you also filed your matters here and you may also have a lot of things to say. र सरले पनि आएर भनिदिनुहोस् न त एक दुईवटा कुराहरू भन्दाखेरि आई थिङ्क सम ओल्ड स्टाफ यु मे रिमेम्बर लर्डसिप पनि आएर इन्टरेक्सन गरेको थियो नि त, है कि होइन, लु भन्नुहोस् त। र त्यो गर्दाखेरि हामीले के गर्यौँ भन्दा त्यति बेला एसओपी त होइन, तर हामीले चेकलिस्ट बनायौँ। चेकलिस्ट नट ओन्ली फर वान केस, माइन्ड यू, चेकलिस्ट फर अल द केसेस। तपाईँहरूको रिट पिटिसन सिभिलमा फाइल गर्दाखेरि वाट आर यु सपोज टु सी? रिट पिटिसन क्रिमिनल अदरवाइज अरू रिट पिटिसन फाइल गरेको छ भने वाट आर द थिङ्स यु निड टु सी? एमएसी मोटर एक्सिडेन्ट क्लेम ट्राइब्युनलकोबाट अपिल आउँदाखेरि वाट आर दि फर्मेट द्याट यु हेभ टु सी? इफ देयर इज the first appeal, or if there is a second appeal, civil appeal, what are the requirements that you have to keep in mind? If there is a criminal appeal, what are the requirements? And from one to all, cross complaint देखि हामीले सबै गरेर checklist बनाएका थियौँ। I do not know whether you are using that checklist or not, but I urge you, please take out some time, see that checklist, and whoever is there to verify it, जहाँबाट तपाईँको त्यहाँबाट पास हुन्छ नि, you will be able to see that तपाईँहरूकोबाट एउटा पनि गल्ती भएको छैन भनेर नि। Because then you will checklist, यो छ छैन, यो छ छैन, यो भयो भएन, यो भयो भन्यो भने if everything goes right, then you pass it on to your senior, and then your senior validates it, and then it goes to the court. No problem at all, होइन त? But if you rely on your memory is good, but if you rely entirely on your memory, sometimes our memory fails. Sometimes from that checklist you miss one or 2 points which may lead to inconvenience, and sometimes quite an important matter may come up in the court and which will actually cause an embarrassment to the whole section. र मैले यो भनेको कि have a look at these things which are already ready made, होइन? All you need to do is take a look. तपाईँहरूलाई, and I will not take credit for that, for making or preparing this checklist. यो checklist मैले मात्रै बनाएको होइन, यो checklist हामी सेक्सनमा हुँदाखेरि सबैको, हाम्रो सबैजना सेक्सनको त्यहाँबाट उहाँहरूले यो हुनुपर्छ, यो हुनु पर्दैन भनेर त्यति बेला हामीले बनाएको, होइन त? मिस सम्झौता हुनुहुन्थ्यो, होइन? हामीले रिडर्सहरूको सबैको भ्युजहरू लियौँ, र इफ यु फिल that you require modification, you are free to modify, you are free to use it in any manner so that it can help your work.
Despite of that checklist, is one of the checklist. One of the thing that is mentioned in the checklist is whether they have filed the particular writ petition, criminal appeal under the provision. So actually, I wanted to ask to the director, sir, about the limitation. Usually, they file application under Section 5, but there are certain acts like Motor Vehicle Act, Family Codes Act. Whenever there are MAC appeal and certain other appeals filed under the other act, they also have the delay section out there, mentioned out there. So like when we give it as a defect that they have not filed under the provision, there are certain lawyers who says that they will, whatever the argument is there, they'll apprise the court and the registry is not to act as a court. So at that point of time, how do we deal? And then when the file is taken at the bar, the first question comes before the court is that why didn't the registry check? So that is a particular practical problem which we all are facing, whoever sits at the court.
Right.
So how do we deal with that?
See, whoever is checking these files, if you find that there is clear, the limitation, it is clear that this matter is barred under limitation. Some matters are evident, right? Some matters there is a grey line. You are not able to actually make out there is a limitation or not. So whenever there is a clear matter, you will have to reject it. Whenever there is a thin line, you make your note, because along with your file there is an office note. Isn't it so? There is an office note which the officer prepares. So in your note you mention that goes to the court, but you will have to see that if there is delay, there has to be an application under Section 5 of the Limitation Act. There has to be a condonation of delay application.
Yes, sir.
Otherwise, what happens is the court will then ask the particular officer, there is a delay here, or they want to apprise the court or argue in the court that there is a delay, but it is because of these reasons. But where is an application for condonation?
Yes, sir. So the practical problem which we are facing right now is they usually invoke Section 5 of the Limitation Act.
Right.
But in the Motor Vehicle Act, it is already mentioned that they have to file perhaps under Section 173 or 70, 73 or 70, 176. And in the, like, for example, even in the Families Courts Act, if they have to file a matrimonial appeal, there is already a provision which provides a limitation, 30 days, 60 days, like in arbitration.
See, even if there is a provision under the Act, yes, but if they have a genuine reason that they were not able to file it within that particular time, the Limitation Act gives, Section 5 Act gives an opportunity to that party to explain to the court as to why there was this delay. So it is not that you may not stick on that it is 30 days. No, you have not filed it within 30 days, I am not going to take it at all. If there is an application along with that under the Limitation Act, please allow, pass it over to the Honourable Bench and let the Honourable Bench decide. Because at times there are genuine reasons. Let's say, for example, under the Motor Vehicles Act, earlier there was no limitation. There was limitation earlier, but later on what they did is, they stopped that limitation and it could be filed at any time. And then what happened is, after this amendment of 2019, there is again a limitation, 1663 of the Motor Vehicles Act 1988. If you don't file it within 6 months of the date of accident in the tribunal, then your suit gets barred. That is the law. But the wider interpretation of the courts, of the Honourable High Courts, many High Courts, is that if there is an explanation ready, if there is a proper explanation, if it is reasonable, it should be allowed. So what we are trying to do is in the court, my experience was that don't make it too technical. People have come to the court with some cause. They have a cause to come before a court. So don't stop them at the threshold by saying that you have not followed this rule is not there. What is this practice and procedure which Sir was talking about? What is it? It is a guideline. It is a guideline so that you can streamline the cases that comes to the court so that there is no chaos. But at the same time, that guideline should not bind you that a genuine litigant is kept outside. होइन म यही भन्छु नि कि don't look at a code or a rule with a hyper-technical view. See it with an open mind. Whenever there is some cause, allow them. Go to the court and then it is for the court to decide. If we stop them at the threshold itself, saying that sorry, yeah, this defect, that defect, palnago defect, small defects, no. म त भन्छु whatever it is you file it. Sometimes it happens अलिकति कोही बेला प्रिन्ट आउटमा अलिकति तलमाथि भएको हुन्छ त्यसमा पनि डिफेक्ट नो But the court can see it. If you can understand that particular document, there is no reason why you should disallow. Because every application, please keep that in mind, every application that is filed before a court, it pinches the pocket of that litigant. त्यो एउटा application courtमा जुन चाहिँ आउँछ नि, it could be an IA. It is filed by a lawyer. But who pays for that? It is that litigant. And not every litigant is rich. In a country like ours, there are poor litigants, which makes the majority, the major chunk. So what you have to understand is that we should not disallow the litigants to come to the court because of these small reasons. There are courts, there are benches. It is for us to see that the majority of the rule is followed. Thereafter, it is for the honorable courts to decide. I know you got my point? Alright. So, moving ahead, I'd like to tell you a little bit about digitization. I know there are new faces here. So, what happens is, I think somewhere in 2016, we started digitization process in Sikkim. There is a digitization rules as well. In the High Court, all the court files, beginning with judicial files, the court cases files, it was digitized. If I remember correctly, Shyam was there. He was manning the digitization of records. Then it was to be followed by the administrative files. Recently I saw one quotation, a quote from CPC here, Benoy sir, 2024, if I'm not mistaken, calling for quotations for digitization of records again. This is a continuous process because digitization doesn't stop. There are new filings, all these filings have to go and it has to form a part of the record. And we have done, I think, almost 90% is complete. The major chunk is over. There are some, and since it is a continuous process, the new ones are always coming up and it is getting digitized. And why is it necessary? These are necessary in order to retrieve the files whenever or wherever you want it. If you have a physical record only, it becomes very difficult. Number one, there are chances that it may get destroyed. Number two, your space gets filled. You have no space at all to keep these new files, And number three, you require one document from one place to another, but for that you'll have to carry that entire file. I can understand how difficult it is to retrieve one file from a record room. if you have not kept it properly. तर कतिवटा त हुन्छ नि त, you have from 1950s, होइन, you get that 1950 file and the papers are almost, it's almost in the state of, when you touch it, it is destroyed, it's like fragmenting. So if you have a digitized records, you can use it for posterity. So digitization is very important, and in a age that we are, and the age that is to be followed hereinafter, digitization is the rule, and we'll all have to get used to this process. All right, these are the benefits I've just highlighted. You can just take a note. All right, security, and for those again newcomers, you'll have to see is when you digitize, there are three kind of records. One is the civil records, which you digitize. The second one is the criminal records, and the third one is of course the administrative records, which you have to digitize. All right. Any question on this before I go to the next session? You can just take a look. I don't want to waste much time. All right. So let me go to the next slide. Of e-filing protocol. E-filing भइरहेकै छ हैन त, र there are certain procedure, there are certain protocols that are required to be maintained in e-filing, which all of you should be able to understand. And also the change in the courtroom ambience, the atmosphere in the courtroom has changed. I think if you compare it, let's say even 2010 and now 2025, there is a drastic change in the courtroom environment. The readers will be able to understand. There was no computer at all. There was just a typewriter. Slowly the computer started replacing the typewriter, but the computers were being used merely as a typing machine. र कतिजनाले के गर्थ्यो भन्दाखेरि even the font, there was no change. Sometimes the spacing, sometimes it's here and there. So I remember what one of our teacher in the computer said, that don't use it as a typewriter. Typewriter you cannot change. Once you type it, you cannot change because it's already typed out. But here you have a computer, you can change the font, you can change the style, you can change the spacing, you can justify right, left, center, another bold, italics. So then came the computers. Now slowly what happened? We started, I also happened to work as the CPC, and it was my good fortune to have worked with young minds, not only in judicial section but in the computer section. They came up with an idea that, sir, let us try to convert our courts into paperless. And I said, great, I think that's a good idea. The honorable judge in charge of the computer cell, he supported, and then we began this process for paperless court. The software was prepared. We purchased computers, replacing that old computers with touchscreen computers. Though it is not like the present Wacom computers, but we started. And there was this scanning which was going on, scanning and digitization process which was going on together. And then it was easy for us to get those files and put it as a soft copy. It happened for a brief moment, and I do not know the reason why it stopped, but What I'm trying to tell you is that the court's environment is changing drastically. Now from touch screens, not only for the bench, for the bar as well, it was given to them. The Wi-Fi was open in the High Court for all to use, the litigants and the lawyers as well. And now the latest one is your live streaming. The live streaming has come. The machines have already been given by the present CPC. I think these are one of the best equipments that we have it. Now the only thing is to start. And we need live streaming for what? There are important cases. There are constitutional matters. There are matters which people are all around the world, or maybe in our state, people from various districts, they are interested in to listen to that particular hearing. But how do they do it? They will have to come all the way from the districts for that particular case as well, only to listen. To make it easier, we can do it through live streaming. Now I believe that there are already employees, there are already technical staff appointed for live streaming of the court procedure. So these are the changes that has gone by from the time of our typewriter that I have seen till the present one, the live streaming of court procedure. And one important thing which I remember is that I happened to be there in the computer section as the CPC during the time of COVID. When the COVID-19 hit, the entire world crippled the system everywhere, and we were not an exception. So that was the time, and that was a testing time, not only for every one of us, but especially for the computer section, the technical staff, and the officers. What we have to do is we have to fix VCs, the video conferencing system, in all the courts, not only in the high courts, but also all districts and taluka courts. And that is the time I think everybody, you did a commendable work, because that was a time we didn't know whether we should come to the office or not. What is this virus, whether we are going to survive or not. A lot of uncertainties, but the cases had to go on. There were clients whose lives were at stake, whose property was at stake. So the courts all over India said, we are open. We are keeping the doors of the courts open. Whoever wants to come, free to come. And that is the time we started with video conferencing facilities. And that is the time we also, along with that, had a guideline for use of the video conferencing, how to use it. That was, I think, recently substituted with the present notification of 2025. But these are things which the staff and officers of the judicial section, you should be able to understand, comprehend, and have some, if not adept, some knowledge of the use of these technologies. So this is the e-filing protocol. Sorry for the paperless courtroom, live streaming of cases, your video conferencing. And also another thing is, we, I think, should, as far as possible, try to use sustainable energy. At least in the district courts, with the aid of e-courts project fund, we were able to install solar power energy in the district courts and taluka courts. So whenever we have power failure, which you hardly experience in the high court, but if you go to the districts, if you go to the taluks, we often do, this sustainable or the alternative energy that we have keeps the courts going. I'm telling you this why, so that you will have some knowledge about not only how the High Court functions, but also the districts and the talukas, from where actually the place where the common people first come. All right, I will stop with this and do is let us have one sort of a quiz on your e-filing, all right? Because I think I'm talking too much and I can see some people are bored, some people are perhaps yawning. Why not? Is it visible? According to the, I'll read it. According to the e-court filing rules of 2020, what is the maximum permissible size for e-file documents? What is it? Anybody? Yes, please, I want participation, yes.
So, 50 MB.
Let's see. Not quite right, but it is 20 MB. This is based on the rules of our e-filing. And it says the reason, because it should not exceed the limit. Sometimes it becomes otherwise too heavy for the system. All right? But it's a good try, sir. I want participation. Others may follow his suit. Which of the following is the preferred document format for e-filing in the High Court? What is the preferred format? Not Mr. Shyam, he has technical background. Yes, others may please say something. Yes?
A.
Sorry?
A. Option A.
Option A is what, sir?
JPEG.
JPEG is normally a photographic or image file.
So it's
D. Let's see. Yes, it is the PDF file, but with optical character reading facility, right? What is the primary web portal for the online e-filing of the High Court? What is the primary portal? कहाँबाट चाहिँ उहाँहरूले e-filing गर्न सकिन्छ? B. What is B, madam? courts.gov.com. Anybody else? सबैजनाले यही हो? Okay. It's not quite right. It is the e-filing portal of the e-courts, from where we have a common. From that portal we can file it. What is the document required for an advocate for registration of the e-filing portal? What are the documents required if he wants to get registered in the e-portal? Yes, I think normally this is done by the officers, What are the documents required?
So the documents are required.
यहाँबाट मैले अप्सन दिएको चाहिँ थर्ड अप्सन फोर्थ अप्सन छैन हजुर
So I think it's A.
A. Let us see. That's right. It is mandatory that you have to verify the credential of an advocate. अब ऊ हो कि होइन नि त होइन उसको त बारको लाइसेन्सहरू आउनु पर्यो नि त. What is the official paper size? Sorry? A4. That's right. It is A4. It is followed all over the country. What is the prescribed font for pleadings along with size? Yes, पछाडि पनि भन्नुपर्छ है. पछाडि दुईजना को हो? Mr. Nasir and Pawan. भन्नुहोस् त. Take a guess and tell me. Sorry? D. D. Everybody D?
Sir, I think it's A.
It's A.
So just guess.
Okay, D, A, then
B, sir.
B. Anybody for C? कोही छ? C छैन. So let us see what is the right answer. It is Times New Roman. Font size 14. You can't say भन्दैन हाम्रो रुल्समै छ है. You'll have to see these rules. Now whoever is checking, you'll have to see यो भएको छ कि छैन भनेर नि. So the next question is, if an e-file document is not a text document, and if it is an image, what is the recommended scanning resolution? Resolution हुन्छ नि है, DPI भनिन्छ हामीले. What is the resolution recommended? 300 is C. Yes, others? Everybody 300? कि पछाडि कोही छ अलिकति? हजुर? भन्नुहोस्. See, what I'm trying to do is I'm trying to let you all participate.
So I think it was increased to 600.
600 DPI.
So I think so.
Acha. That's I think, you know why? Because the more resolution you have, the clearer is the picture. I know. But clearer the picture, more the DPI, the heavier is the file. उसको MB मा increase हुन्छ नि त हैन. The more heavy it is difficult for your system to handle. किनभने पछि त यो गएर ब्याकह्यान्डमा त सिस्टममा जान्छ नि तपाईहरुको. But let us see what is the right answer. Somebody said 300 DPI, हैन? 300 is the right answer for our rules. Come back to the next question. त्यहाँबाट देख्छ तपाईहरुले क्वेशन? पढ्नुहोस् त लु एकजनाले. कसकोमा माइक छ भनिदिनुहोस् त. किन मेरो घाँटी नै दुख्यो बोल्दा बोल्दै. अलिक जोडले भनिदिनुहोस् त क्वेशन. पढिदिनुहोस् न. पछाडि को हो? Who's at the back? No, madam, the phone, microphone was with you? That was with you, no? Okay, you tell me, madam, please. Yes, you read this.
Actually, I can't read.
You can't see, okay. All right, you have a problem like me, sir. Anybody here?
What is the procedure for an advocate for litigant who does not process a digital signature for e-filing?
लु, जसको एडभोकेटमा चाहिँ ई-फाइलिङको इक्विपमेन्ट छैन, यन्त्र छैन, उहाँहरूले चाहिँ अल्टरनेटिभ के गर्न सकिन्छ भनेको नि. सी. Who's for C? Who's for A? Who's for B? B छैन. C? C. कतिजनाले त हातै उठाएन त. तपाईहरु चाहिँ के अन्त भन्नुहोस् त. दूध भात. Let us see. Who said A? Okay, let us see if it's from A. That's the right answer. You can have it scanned and upload it. Now this is the last question, okay? Because the 10th question, the Gemini didn't support it. But what is the e-filing module, an e-payment system for the High Court of Sikkim? This is just a general question. When was it launched? कहिले चाहिँ यो launch भएको थियो? हजुर भन्नुहोस् त, पुरानोहरूलाई त थाहा हुनुपर्ने होइन? Yes?
So July 8, 2024.
July?
2024.
2024 ma. Okay. Anybody else? August 3rd, 2020. Okay. For B? B, okay. Sam is for B. 26 June 2020? Let us see. Madam le ke भन्नुभयो?
So July 8, 2024. Option D.
Okay, let's see. Option D is not right, but it was on 3rd of August 2020 when it was launched. But I think this is a good response that I've got from all of you. And let us see how we fared we are 60% accurate. One we skipped. So it's not bad. These are the rules that we follow, and my only purpose to show it here is so that you all can participate. Now I will come to the end of my presentation. And I was quite confused. Interdepartmental coordination भन्दाखेरि मलाई लाग्यो कि there would be other staff of the High Court who would also come here so that I can tell what is interdepartmental coordination. Interdepartmental coordination भन्ने मतलब the coordination between one हाम्रोमा त डिपार्टमेन्ट भन्दैन section to another section. Why are we dependent भनेको नि? It is interdependent. एउटा हातले काम गर्दै अर्को हातलाई थाहा नै नहुने भने जस्तो नि नभए है? यो हातले के लेख्दैछ यो हातलाई थाहै छैन हुन्छ कि हुँदैन भन्नुहोस् त तपाईहरुको अफिसमा त छोड्दिउँ न, तपाईहरुको सेक्सनमै थाहा हुँदैन कोही बेला रिडर्सहरुले के काम गरिरहेको हुन्छ तल सेक्सनको अफिसमा थाहै हुँदैन हैन त? फाइलिङमा के गरिरहेको हुन्छ यता रिडर्सहरुलाई थाहै हुँदैन। लु हो कि हैन भन्नुहोस् त? This is I think absolutely true. So there should be a coordination between all the staff members, not only within the section but apart from the section, with other sections. Kiन भन्नुहोस् न? Because at the end we are all interdependent. We can't work in isolation. हामी खाली जुडिशियल सेक्सन मात्रै हो, हामी मात्रै यो काम गर्छौँ भने सकिँदैन हैन? कन्फिडेन्शियल सेक्सनले हामी मात्रै यो काम गर्न सक्छौँ भन्दा सकिँदैन. You need the help and you need the support from all the sections, and so they do. Let me show you. So far as you are concerned, तपाईँहरुको inter-department, not only within your section, but sometimes you need to have correspondence with other agencies as well. तपाईँहरुको पुलिसहरुसँग कोही बेला interaction हुन्छ, कोही बेला जेलहरुसँग तपाईँहरुको हुन्छ है? This is one particular case where the courts, the judicial section should note that in this case, the Honorable Supreme Court said that bail order, bail order bail order will have to be sent immediately. What has now come is a software known as Faster. I know who operates Faster here?
Sorry, Registrar.
So this is a software where the bail order is uploaded. Same day it goes to the jail. Same day it goes to the court, wherever it is. And the purpose is that there should not be delay in release of the prisoner. So this is in this particular, this is in the case of, this is policy strategy for grant of bail. This is a 2023 case, which you should know. And these are the stipulation. If it is not released, though not absolutely necessary, but you should keep a note. 7 दिन भित्रमा रिलिज गरेन भने के गर्न सक्छ त भन्दाखेरि नि. So this is what it can be done. It has to go to the DLSA secretary and so on and so forth. All right. Now, yeah, अरु त छैन, but whenever there is an inter-department coordination, juvenile justice committee छ हाम्रोमा buildings committee छ. There are so many committees where you require the coordination between, not only between the sections, but you have to look for coordination and cooperation elsewhere. Juvenile justice ma ke cha? The social welfare department, the women and child department is one of the implementing agency. त्यहाँबाट data collect गर्नु, यो गर्नु, त्यो गर्नु. There is this secretariat, and at that time Miss Pauline was the assistant registrar. उहाँलाई secretariat को one member बनाएको थियो. In the building we have this buildings committee, the rules committee, protocol section, so on and so forth. The last topic that I have been given is your conducting सेरिमोनियल फङ्सन्स भनेर नि र तपाईँहरूले कसरी कन्डक्ट गर्नुपर्छ के गर्नुपर्छ भन्दाखेरि नि वाट डु यु सी इन दिस पिक्चर विच इज नट टु करेक्ट हजुर ड्रेस कोड what do you see in this picture which is not too correct हजुर your dress code अब हाइकोर्टमा धेरैजना नयाँ स्टाफहरू पनि आएको रहेछ है डिस्ट्रिक्ट कोर्टमा पनि देयर आर नम्बर अफ न्यू स्टाफ बट वाट आई हेभ नोटिस्ड इज ओभर द इयर्स the officers and staff have given a go-by to dress code. होइन ceremonial functionहरू हुन्छ ceremonial functions are those functions which are important. Number one, for your section, full court reference हुन्छ होइन at the time of normally farewell of the judges in the courtroom, Registrar General, Registrar हुन्छ, they are in their full uniform, court uniform, judges on the dais, advocates in their full uniform with gown, with your band होइन र बिचमा यस्तो बस्दै हुन्छ कस्तो हुन्छ भन्नुहोस् त एकजना स्टाफ चाहिँ त्यहाँ घाँटीमा यत्रो चेन लगाएर हो कानमा कुण्डल लगाएर बसिदियो भने त राम्रो देख्दैन नि त होइन स्टाइल इज अ डिफ्रेन्ट थिङ बट टु ड्रेस अप appropriately for that occasion is another thing. For the old staff, that is not a problem because they have already experienced. But for the new ones, please make a note that in ceremonial functions, not only ceremonial functions, at least I would like to say that when you come to the office, come dressed up appropriately. Shirt pant लगाउनुहोस् न त हैन जिन्सहरू लगाएर कतिजनाले कुण्डल झुन्डाइरहेको हुन्छ कतिजनाको केस यहाँ हाम्रो सरले त कसैको दाढी पनि राख्न दिँदैन थियो उहाँ त दाढी राखेको देख्यो भने पक्रेर तासिहाल्थ्यो होइन सर उहाँले कुण्डल लगाउनु त कसैले लगाउनु दिँदैन थियो सो दिज आर थिङ्स विच यु सुड रिमेम्बर वेन यु कन्डक्ट यर सेल्फ ड्युरिङ फङ्सन्स नम्बर वान बी पङ्क्चुअल तपाईँहरूको फङ्सन्सहरू हुँदाखेरि के हुँदाखेरि इफ इट इज एट 9 o'clock कम एट 8:30 8:30 त हामीलाई सक्दैन हुँदैन गाडी पाउँदैन यो पाउँदैन भने सेरिमोनियल फङ्सन्स आर नट एभ्री डे इट ह्यापन्स समटाइम्स 15 अगस्त हुन्छ अस्ति भर्खर भयो होइन 26 जनवरी हुन्छ दिज आर अल सेरिमोनियल फङ्सन्स बी पङ्क्चुअल नम्बर 2 ड्रेस अप इन अ प्रपर म्यानर सिट रिस्पेक्टफुल्ली होइन एकजना यस्तो बसेर खुट्टा माथि लगाएर चौकीमाथि यस्तो लगाएर अर्कालाई चप्पल देखा द्याट इज नट द वे यु सिट इन अ फङ्सन इन अ प्रपर फङ्सन अनि जब वन्स दि प्रोग्राम इज ओभर गुटुटुटु बाहिर निस्केर हुन्छ नि त्यस्तो होइन लेट द गेस्ट एक्चुली गो फर्स्ट एन्ड देन फलोड बाई the officers and staff for High Court because you should remember is that in the High Court whenever there is a function we are the host and they are the guest र गेस्टको अगाडि कुदेर त्यहाँ खानेमा लाइनमा बस्यो भने त भएन नि त होइन गेस्टहरू पछाडि ठेल्यो भने त भएन सो डोन्ट रस हाम्रो माथि के हुँदो रहेछ भन्दाखेरि which I didn't know and I just wanted to put this दुईवटा डाइनिङ राखिदिएको छ यतापट्टि एउटा डाइनिङ छ उतापट्टि अर्को डाइनिङ छ अब उतापट्टि के हुन्छ मलाई थाहा थिएन तर त्यहाँ के हुँदो रहेछ भन्दाखेरि कतिजना अब मैले यहाँ तपाईँहरू गर्छ भने होइन है बट दिज आर थिङ्स विच यु सुड टेल यर काउन्टर पार्ट एज वेल लाइनमा बसिरहेको हुन्छ कतिजना होइन द्याट इज द वे हाउ यु सुड यु कट द क्यु कसै लाइनमा बसिरहेको छ भने अगाडि आएर बसिदिन्छ पछाडिहरूकोलाई मन पर्दैन कतिजना त अब जुनियर हुन्छ भन्दैन है तर ठिक लाग्दैन नि त होइन वेन यु सिट इन द टेबल सिट प्रपरली लाइन फ्याङ गरेर त्यो सेरिमोनियल फङ्सनतिर बस्नु भएन नि त whenever there is this kind of dinners you respect the other your fellow staff or officer, एकजनाले खाना खाइरहेको हुन्छ, एकजनाले त्यहाँ स्निज गरेर हैन जोड जोडले बोलेर अर्काको भाततिर त्यो थुकहरू लागेको मन पर्दैन नि है. So these are things which are, let's say in a broader term, etiquette, but these are essential for all of you to remember whenever there is these kind of ceremonial functions. र presentation को भन्नु त ज्यादा अब there is, I'd like to leave you all with one short story. This is a story of a pencil. It so happened that there was a pencil maker who was making a pencil, and after he finished making that pencil, he talked to that pencil because it was getting packed to be sent to the market, and he talked to that pencil as if that pencil was a person. अब उहाँले पेन्सिललाई भन्यो अरे उहाँले, to be a good pencil, you remember 5 things. यो 5 वटा कुरा तपाईले सुन्नु, you remember, and you will be a very good pencil. Number 1, you have to get into somebody's hand. बाहिर दुनियाँमा गएर you have to get into somebody's hand to be a good pencil. And when you get into somebody's hand, they will sharpen you. तिखार्छ तिमीलाई, उदाउँछ. You will feel that pain, but don't give up. These are testing times. And whatever you do, you can always correct it by erasing. And what is important for you is what is within. भित्र के छ नि, that is important. And whatever you do, you make a mark in the world, and don't ever give up, whatever be the contingency. Now these are 5 advice that the pencil maker gives to a pencil, and he goes and sends that pencil. And the pencil says that I will keep your word, I will keep your promise, and when you go out, you have to put yourself in somebody else's hand. हैन त? Whenever you come to office, you have to put yourself with, let's say, an officer or another senior who is your senior staff. हैन? You may get this kind of criticism, this kind of pain, but you should never give up, and always try to value what is the inner worth. भित्र के छ, you value that, and never ever give up on whatever you are doing, because if you continue, you can make a mark in whatever field or whatever you do. And that is how I think all of us can also become a pencil like that. So with this, I would like to end my presentation and wish you all a beautiful weekend. Thank you.
Particular conclusion. That may not have been the case in the 50s and 60s, but another disadvantage then, which balances the thing, is that there was no technology where you could search judgments. But still, those judgments are so clean and clear. Still, most of them are the final precedents, even till date, in many of the constitutional matters. So times have changed, and nowadays, as you often see in the memes that come in the social media, that don't work hard, work smart, right? Of course, balancing is required. You just can't think that you're working smart and giving the correct results. Working smart may not every time give you the correct results. Some kind of hard work is also required. So traditionally, we follow even today the traditional legal research. Okay, perusing the literatures, whether online or through books in the library, focusing on analysis of statutory provisions. Now, legal research does not only involve, reading judgments. The primary document that while researching one needs to read and understand is the statute, the law which the case is dealing. That is first is to be read. When you see certain statutes, for example, let's say Indian Evidence Act, some of the provisions are still not finally determined. There are judgments, but it does not come to all your situations where it can be applied. This IPC, then, now still, for even when the new law has come, IPC, the judgments therein are still relevant because the sections are pari materia to what we had before. These two are very old laws. Now, the problem that comes with these two old laws is either there are too lot of determinations in a particular case. You'll find so many literature there that you yourself get confused as to, what's the interpretation. Or some of the provisions are very less interpreted because it never reached the higher courts. Now, to such an extent that, Honorable High Court has issued a circular that magistrates need not be called for giving evidence if they have recorded 164. Now, is the law so unclear that we need a notification? Why were the judges doing it? If you read this law, for a judge who is sitting there, whether to call the magistrate or not for the determination in that case becomes quite difficult because a document has to be proved. Though there is a provision in Indian Evidence Act which says, anything done officially need not be proved by the person coming it. But what about the document that has been prepared? Who will identify that? So what the honorable judges in the district courts are doing that, unless there is a dispute or there is a certain doubt in the mind of the judge that a magistrate should be called to prove that documents or the contents therein, then they are summoned. Otherwise, usually it's not summoned. These laws are very old when at times, issues were very less. Nowadays, everyone has, everyone can open their computers and do even a bit of legal research to find whether a particular process that is being conducted in the courtroom is right or wrong. You will definitely get certain answers. So issues become more and bigger. A good lawyer, would. I'll give you one example. When I was a civil judge cum judicial magistrate in Mangan, one of the cases had been transferred to Mangan. Most of the cases used to get transferred from Gangtok to Mangan for certain reasons. And I did one civil case. That was almost one of my earlier first judgments. I thought I had written it very well. Though ultimately it did not reach the High Court, but the Honorable District Judge, they upheld what I said. But I read the memo of appeal that was filed before the District Judge. I somehow got an opportunity to read that. When I read it, I found that some of the words which I had used in judgments were torn so much by the lawyer. Torn in a sense that an English word can have so many meanings, right? So that day I realized I have to be very particular about the words also which I use. Try to narrow it down so that a very less meaning that particular words give. So senior lawyers are very expert. They have a vast experience. They know how to, take out a meaning of the words so that to prove that the particular court meant something else than what the actually judge meant. So these will become increasingly difficult in the times to come. Lawyers, everything is getting modernized, Nowadays we have a whole set of new batch of lawyers, and some of them in that batch may be excellent, outstanding lawyers who will try to argue or plead in any form possible to communicate their views about a particular case. So, analyzing statute is very, very essential. There used to be, I do not know whether that has been retained in the new law, a section called 311A CRPC, which says that, the handwriting of a person an accused can be taken for proving the signatures in a document. But at the same time, that section says that, no such handwritings can be taken unless the person has been arrested at some point of time in that case. Now in the above it uses the word accused, below it uses the word person. Whether that person the legislature means it's an accused, intending to be accused, it was a really confusing section. We have such lot of such sections. That still does not have a final determination from any of the appellate courts till now. Some of the honorable high courts have decided on this case, but not on this point. So new points may come to the legal researchers as to what does that provision mean. Now it becomes so, difficult in such situation that in trial courts it's not just the accused whose handwriting samples are taken. Sometimes even of the victim whose handwriting is alleged to have been forged, but the person is not arrested. So can you take the handwriting? The law says the person has to be arrested at some point of time if the sample handwriting is to be taken. So we have law of interpretation. A purposive interpretation is to be given. A law cannot be negated by giving a difficult interpretation which does not push forward the cause. The whole purpose of that section is to see that the samples are taken and evidence comes in record. So a researcher needs to move into a purposive interpretation instead of literal interpretation, though the first rule is literal interpretation. Then if that is not giving a solution, then we move to another method of interpretation. When all interpretations are exhausted and you still don't get a solution, probably the courts would stick to the literal interpretation and say no. As we all know that law, you cannot put a full stop to law. What is law today changes to tomorrow, sometimes very swiftly. Right? A few years back, for aspiring persons who wanted to be judicial magistrates, you need not have any practice experience in the court, but the recent judgment says that you must have 3 years of practice. Many disheartened, many happy. So law is not static. So I've been in the administrative side of the High Court since 2022. To be frank, I am not in touch with the present developments in the law. Why? Because my job does not demand it. Probably there is less time also to go into that and study. And as you grow older, you have much less time. Your responsibility increases, you go on to somewhere. So as long as you are young and when you're initially in the job, then you have that all zeal and all. But we must not lose that. What runs in the back of my mind is one day when I go to court, I can catch it up. So after the statute, what comes is the legal principles. Now all these judgments which decides a particular fact or an issue in law have certain legal principles either followed or a new principle would have been developed. So once you are clear about this statute, next is what the legal principle involves. Through logical reasoning, right? That legal principle may be applicable to your case, but the facts are different. So what is the logic or how much of such principle can be borrowed into that case has to be looked into. Initially, you will start with the presumption that the legal principles will apply and I'll have to borrow it. But all situations are not same. So you can have your own view as to why that legal principle cannot be applied in a particular facts of case. Very important thing is you must look it critically. You just cannot, read the judgment and say, okay, this is applicable, unless the facts are so similar that you have no way out. One of the important thing, and these are very briefs I'm telling, okay, because I said earlier it's a very vast subject and you cannot go into everything. Procedural history timeline. Now, if you analyze the cases which you are referring to, sometimes their procedural history becomes very important as to how that case reached the Honorable Supreme Court. It is not something substantive that may be used in the issue that is at your hand, but sometimes the history of that case traveling particularly to that court becomes important so that you are much more clear as to why that issue arose. It's not just that issue has arose in the case, why the issue is arising is very important. And one thing you will find is, the same issue being repeatedly, raised particularly in the high courts, by the councils, which has already been given a quietus by the Honorable Supreme Court. So unless the issue is such that it's a new one, if the issue is being raised again for one of the reason or the other, then you can be very sure that this issue has already been closed. There is no need to raise issue. In fact, some of the pleadings have, I think, about if it's a 20-page pleadings, it would be making submission on about 15 pages on the same issue which has already been decided. In such cases, your jobs become easy. So procedural history timeline in some matters may become very essential to peruse as to why that case reached there. Now if you see the Ram Janmabhoomi case, right, it has a huge long procedural history timeline. From the trial courts being, the case being rejected under 711, again under some other provisions, so many applications, miscellaneous applications being filed there. I think if you look into the research into this judgment, you will have one fact book on it, because that case stood more in the trial courts than in the appellate courts. Its procedural history timeline, probably if you read this judgment, that the Honorable Supreme Court has referred to all these timelines that from the beginning of the suit in a civil court. Legal issues presented, okay, this obviously in the writ petition especially, there will be legal issues presented by the parties. So what are the legal issues involved? You need to identify that. Reasoning and principles involved. Now sometimes more than one case or two or three cases may have the same principles involved, but the reasoning may be different because the facts are different. As legal people who have studied law, we know that there is no two cases which is absolutely same, except it's a very rare occurrence. Precedential value assessment. Now, not all cases are precedents, right? Who would know better than the legal researchers here? The precedent, a judgment only becomes a precedent if it is matching your facts, at least 90%. Otherwise, you have a new fact to deal with and the precedents don't come to your rescue, or it comes to your rescue only halfway through. After that, now judge, you decide. Okay, there's this situation that comes in the cases when precedents, if it was so easy to take precedent and decide a case, then there was no problem for the judge. Okay, this is the precedent, finish. One-page judgment would do everything. But the longer the judgments, the more intricate issues are involved there. So whether a particular judgment, instead of printing and downloading everything and giving it to a judge, you need to be sure that this particular judgment does somehow apply to this case. Because as a judge, we see in the courts that when the lawyers file their synopsis, which is more lengthier than their actual argument, synopsis must be very short one, a brief of what has been argued. But in courts we get synopsis which are much more longer than the actual argument. Actual argument does not even last for 10 minutes. Or sometimes they directly give the saying, this is synopsis. Actually that's a detailed argument, not a synopsis. So, they tend to file all kinds of judgments, about 10, 15 high court judgments, leave alone the parent high court of which the trial court is in the jurisdiction, but many judgments from the other high courts. Then sometimes you just get to read one, and it talks about the point which the lawyer is trying to say. Forget about the rest 14 judgments, not required on the same point. So differentiating, if 15 judgments have been filed by the lawyers, legal clerk or research assistant or readers need to see which of the judgments are talking on the same point, needlessly wasting the time. You can pick one or two and inform the honorable judge that the rest are all on the same points, so not required. And all of these may have a precedential value. When a judgment has a precedential value, the court is bound to follow it. If it's Honorable High Court, the judgments of Supreme Court they are bound to follow it. If it's Honorable High Court single bench, the judgment of division bench on the same point, they are bound to follow. If it's a trial court, the judgment of High Courts and Supreme Court, they are bound to follow if it's a precedent. If it's not a precedent, the facts are different, the court is not bound by it. I know one or two judgments of the Honorable High Court where they have not followed because the facts were different, right? Though those cases are discussed. Now this critical evaluation notes, I'm sorry, this is very important. Now as a reader or a researcher, you are not a robot. You have studied law, you may be having a certain view which you are not agreeing with considering the present facts. So I think you should feel free to talk about it politely to the Honorable Judge. I've read all this, but still somewhere I feel that wouldn't it be in this manner? No one likes to be taught. Okay, particularly when these judges, including us, are called learned. Okay, but that's a word used, but we need to learn sometimes. Some person, especially with the younger generation who are readers and all, you are in touch with the present legal judgments that are being delivered every day. So maybe a judge may have forgotten certain judgments on the same point, but if you are finding it, you have to tell it. I'll give you one example of, I usually used to say in the courts that if we were pilots, judges, we have crashed the aeroplane so many times. So I always, when it is said that the job of the judge is very difficult and all, I used to compare myself to pilots. That is much more difficult. You have about, at least even in the smallest of the plane, you have about 200 people's lives on your hand. A single mistake can destroy everything. Thankfully in the law no one dies. Even when there is a capital punishment pronounced, the Honorable High Court has to confirm it, and then so on. The process saves it. But for a pilot, no process can save what it does, right? If you get time to, you can watch series on these pilots, how their personal lives are monitored by the companies to see that the person does not go inside the cockpit with all tensions and all. But it's a human being. They can always have their family tensions or whatever other tensions, pay scale tensions, right? At one point of time when Air Vistara pilots protested against low payment as compared to other airlines, then some of them were still flying, but it was in the back of their mind. Similarly, in a courtroom, a judge cannot go inside the courtroom with taking all these baggages from home and all. Though once trained and once a judge becomes particularly familiar with the courtrooms and his job, my experience says that once you sit in that chair, nothing comes in your mind except the case. But there could be tendencies to come, right? So, a critical evaluation in this context is very, very important, because if you sit like a robot and say that, okay, let's follow this, then there's no point. A legal person should always have a critical view of what is being said in the judgments and then reach a conclusion. So this could be lacking in our readers, because the way the system works is quite different. So for your own benefit also, you can have sometimes for yourself the critical evaluation of the particular judgment that you are researching and giving it to the honorable judges. So this is the basic in researches. As I told you, don't forget procedural history timeline, legal issues being presented there, reasoning and principles involved, precedential value assessment, and critical evaluation notes. Please, legal clerk, no? I'll give you an example. If she was there, I do not know, because we discussed quite a lot on these legal issues. There was one case filed before the Honorable the Chief Justice under arbitration. This was an appeal, right? But that appeal ought to have been presented before the principal civil court. Now everything got solved. The law was clear. But which court is the principal civil court? Everyone started saying district judge. I was of the view it could be a court of civil judge come judicial magistrates, civil judge senior division as well. So we discussed, but everyone is saying district judge, but where does it say it's a principal civil court is district judge? I forgot the statute which she brought. There is one law which refers to the court of district judge as principal civil court. There is one statute. So though it is not a law that deals with arbitration and all, but you had some foot to rest on to call the court of the district judge as principal civil court. Because if you see in a civil law also, the district judge has an independent pecuniary jurisdiction. right? The territorial jurisdiction between a civil judge, senior division, junior division, and among the district judge are similar in our state. Okay. But when it comes to pecuniary, there's a difference. So it is just because the district judge court is the highest court in the district can be called a principal civil court. So a little bit of research was required in this. I forgot really, if she was here, I would have asked her, the statute. There is one or two statute which for some other purposes calls the court of district judge as the principal civil court. None other statute says that. So that was sufficient to rest foot on and say, okay, it's the court of district judge where the appeal lies and not the high court. So this is how, once first you read the statute, it talks about principal civil code. God knows which is the principal civil code. All three are civil code, right? So a little research was required. So you have to move on that way. Now there was another topic called judgment summarization. Now how many of you use internet to search judgments and not the manual books that AIR or something? Let's start from our senior most. हाम्रो ग्रह मिल्दैन कमल मिलेर. We are always arguing. Okay. Come on, भन्नुहोस्. तपाईँ त रिडर हो, सिनियर मोस्ट रिडर. एआइआर मगाउनुहुन्छ कि या एससीसी या अनलाइन मनुपात्र खोल्नुहुन्छ कि या त गुगल सर्च गर्नुहुन्छ कि या त एआई टुल्स युज गर्नुहुन्छ, के गर्नुहुन्छ? दिउँ न उहाँलाई manual. अलिक भन्नुहोस् न प्रोसेस के? Give an example which you have did. Difficult one. तपाईँ कति वर्ष हाई कोर्टमा काम गरेको?
18 years.
18 years मा you may have come across quite a number of cases which was difficult, you know. Judges may have said do this, do that. So tell us, give us one example. Let's hear.
Sir, so far I was not much required by the honorable judges to go through the judgments and search the judgments, sir. Actually, I was not.
When एकपल्ट त गर्नु होला नि त.
Sir,
रिडर पो त.
Yes, sir. Sir, leadership at once directed me to search some judgment on a particular issue, sir. So I had gone through the judgment from the physically, sir.
When was that?
With the help of the library section, sir.
कहिले कुरा?
From Manupatra, sir.
कुन year?
You, sir, before the reader to her ladyship was appointed, sir. I was the reader to her ladyship for 2 years, sir. So at that time,
so what you did? What you did?
Not much practice of engaging some. Even at that time, in fact, at that time, legal talks were also not appointed. So,
Yes, yes, sir.
so at that time, I had gone through the topic. I've searched from the.
You remember the topic?
Exactly.
Okay.
So I searched manually from the books.
So what you did to search manually from the book? How easy or difficult was it?
Yes, sir. Sir,
On that context, I asked you the topic, no? Because you go to that particular topic. How did you go there?
Actually, sir, I am not very much well versed in this searching the judgments. Actually, sir.
Why is that?
Because the modern those readers who are appointed after me, sir, they are very well acquainted with the computer, internet.
No. Okay, no, I'm not saying computer. No.
Yes,
Let it be book. I'm not saying don't use book.
Yes, sir.
So your acquaintance is with books more than computers.
Yes.
If I understand that way, what you are trying to tell. So how did you do it in your books? Could you get the correct judgment or what was being intended by the honorable judge? Because if you take 10 to the honorable judge, if I was the judge, I would have said, what junk you have brought? Give me one or two which suffices on the point.
So actually,
I don't want to read 10 judgments, that's why I am delegating the research portion to the reader. Right? Otherwise I could have myself sat on it.
the fact is, sir, the fact is that I was never required by the honorable judges.
I know Kamal will not answer my question. Okay?
Yes, sir, I don't know.
Thank you very much. Let's go to Mr. Basan, though newly, but still you are not very new also.
As far as doing research,
Kamal never answers.
I usually prefer in my earlier days as working as reader, I usually relied mostly on SCC Digest. So from there, I used to.
The online one?
No.
Okay.
The manual. And later on, I also started using this SCC online also. And
Later on means how long did it take you to go there? From the manual to SCC?
I was using simultaneously.
Okay.
Because first I used to prefer the SCC Digest, and later on I used to search it from the online. But as far as this, I mostly prefer SCC only. And now I am also, while doing research, using this Google and this AI tools as well.
Okay, which AI tool?
The ChatGPT and the Perplexity. So I find Perplexity much more precise and
What did you say?
Perplexity.
Perplexity. We get here?
Yes.
Okay, we'll get see that also. And Miss Hangmano, the newest one.
So first, I'm more comfortable using SCC online because that's what I've been using since quite a time. Then my last resort would be to go to AI manual.
AI manual.
So
Okay, why you think you're comfortable with SCC, no? Don't you think there
Because
are other platforms which
AI is also
maybe
there.
as well as SCC or any other thing?
Because it's more easy, sir, to use SCC online, and there's also an AI we can rely on because for just a gist of whatever we are researching, AI could be more helpful. Then we can go for a deeper research. We can go to SCC online or
Okay,
Manupatra, sir.
okay, good. Darshana, can't miss her. You are not reader, no?
So perhaps we've been given the
Yeah, but
additional-
you have worked as a reader and you still work sometimes in the absence.
So for the research work, mostly I go to SCC online. And if it's such a topic that I don't get in SCC or Google, I refer to commentaries also to get a better idea of the topic and then accordingly carry on with the further research.
Okay, now definitely. I get confused between your and her name. Sonu and Neha.
Yes, like Sir said that Sir likes to the judgments which are of 1990s and
Yes, sir.
onwards. So coming from an academic background, I usually prefer to see AIR manuals first because the old judgments gives a very insightful principles of law. Then I take my research to SCC online, Manupatra, then Westlaw's Heen online. So then I sometimes take the help of commentaries when I have difficulty in understanding the legal principles.
Okay, what about the online AIs and all?
Sorry, I totally disagree with my friends that I do not trust
Okay.
AI because I have found certain judgments which were not precise.
Okay, no problem. We'll come to a solution to that also, right? And now Neha.
So for me, it is most comfortable to use SCC
You can sit
online,
down.
and then Manupatra, and then SCC books which are available in the courtroom also. So if the judgments are more voluminous, then I just take the books, and if the SCC online citations are online only, provided online only, so I take the printout. So it is
Okay.
most comfortable for me.
Okay.
SCC and Manupatra. Sir.
Okay, thank you very much, right? Yes, all of you are correct. But book takes a little bit of time. Now in the AIs, today most of, I think including our Kamasa and myself, we have used AI in preparing this, in coming to you. It did not, if I would look into literature, then I would not have finished preparation on this. But yesterday night about half an hour and today morning about 1.5 hours, I just sat on this. My basic job was done, though I may not have justified this topic fully today because it's really difficult for us, including Sir, these are all the extra works that needs to be done at the home. It's impossible to in the office prepare for all these things. In any case, I needed something to help me, right? So I used AI. Now as Daphne pointed out, yes, AI gives you wrong. Okay, but it depends on which search engine, which AI tools you are using. There is effort being done. In fact, I do not remember the name. I am very poor in remembering names and even sections of law. that there are designs going on to make a particular legal AI which only deals with legal database. If you look into ChatGPT or Gemini or DeepSeek or any such other, there are lots now, other AI tools, then they go through the entire literature that is available. They even search the web themselves. So how they are getting data is that, particularly from the websites they are getting. Not all websites are genuine, not all websites give you genuine information. So the data from where it is pulling may be wrong. Right, but whenever you get this, while using AI, moment you get wrong data, you point it out to the AI. That whatever you are given at this particular is wrong. For the next time it will never give you wrong data. So the more data we feed the correct data to this AI, the more accurate they will be. Still they are above 90% accurate, believe me, even in judgments. But what AI does is, it does shorten your time. It does give you time. Suppose if you were to look into the AI book in the library or even commentaries, then you would need at least whole day to read. Some judgments you can't read even in whole day, right? But AI gives you the gist, so that it shows you the path where you should go on. At least it gives you the path. You may not rely on its entire data. That is also absolutely wrong. I would say you need not completely discard it. It gives 90% accuracy, but don't make that your final proposal or whatever you are placing before the judge. But that does give you an edge, shortening the time, and the things which you need to extract, it will extract for you in just about seconds. So that is how AI is to be used, at least as of now. It's still not complete solution to everything, but it does give you a huge leverage in finding out the things that you are looking for. Okay, now it's not like looking for a nail in a haystack, what they say. It becomes a much more easier. So that is how AI is to be used. Please completely don't discard it. Like I would request Madam Daphne also, it helps a lot to find out what you're looking for. Yes, ma'am.
Cases are overruled or like
Yes.
sometimes. So those I found whenever I used AI that certain judgments which though it gives accuracy, but we cannot rely whether it's overruled or it's yet to be decided. If it's a high court judgment, whether it has gone for an appeal to Supreme Court. So on that perspective, like sir said that since it's not a legal research engine, so maybe because
Yes,
that
yes.
could be.
Yes, the solution they are looking into is making a legal AI tool which deals only with law, so that it only deals with the legal data, so that it becomes more accurate. The processes are going on. Someone said that it's not that AI will replace our job, but AI will replace those people in the job who do not know how to use AI. To be frank, that can be still seen even in our office administration. I'm not blaming anyone. People came to the jobs in their own times. Okay, some are very seniors, but when we sit at the hem of the administration, like registrars, for me in computers, also I look after registry job, the registrar generals, they cannot say, I do not know computers, or I am not versed with it, therefore I cannot do it. As Nima sir was pointing, the person who is signatory is responsible. We know a specific case, in particular incident involving me and Kamal. I had to take the responsibility because it was my signature, though it was not my fault. So, we do feel that pinch from the sections that why this is not properly done. Sometimes it's understandable because the person, the education in the past many years was not as it is today. But we don't expect from the new ones who have been appointed to give the excuses which the older generations give. So, the treatment may be different from the registry when it comes to the newer generation and the older generation. We are ready to ignore, not at all times, what fault, basic faults that has been committed by the sections. But when it comes to new generation like Madam Chankappa and the translators here, we would expect you all not to make that mistake, because you all have grown through computers at least somewhere or the other, even if you have not used it personally in the schools or college. So it's high time that technology needs to be adopted. Now for judgment summarization, I just tried today morning sitting down there. It gave me perfect. Okay, let's try one. Judges Association, the recent one case, okay? Very long one. The judgment that I uploaded, and this is what it gives me. If I were to read this judgment, how long would it have taken me? Read a 63 page. Give me an average time. So, no, just summarize. 1 hour. Basan? No one will say less than that, because it has. 1 hour it will take more. So Sonu is much better. For me it will take more than 1 hour. Right? That too when you are presenting it to a judge. So let's say key issues address. LDC is a limited departmental examination. Quota for district judges. The case examined whether the 10% quota for promotion to the higher judicial service via the limited LDCE should be restored to the original 25%. Okay, so on and so forth. Minimum qualifying experience for civil judge, to sit for the departmental examination. Suitability test. LDC quota for civil judge senior division to become a district judge. Minimum practice for civil judge junior division. The court restored the requirement that candidates for the post of CJ junior division must have a minimum of 3 years of practice. Calculation of vacancies. The judgment issued several directions to all high courts and state government to amend their respective service rules to implement these changes within a specified time frame. So this is what are the issues involved in this case and what has been decided. Okay, let's add more. It does not obey the grammar rules. Okay, not required. Even the spellings can be mistaken. Judgment can be viewed as a progressive step towards enhancing meritocracy and efficiency within the judicial system. Now to write these 2 lines, as a human I have to read the entire judgment. My mind should think that this is a progressive judgment. So then only I could write it, right? Promotion by merit. Accessibility, and now this merit word it is using for the first time. Now why this quota is being increased? Because the Honorable Supreme Court has said there are so many meritorious candidates in the senior division who do not get promoted because of seniority. But if you have an exam, then the merit will come through. That's how civil judge can rise faster to the hierarchy in the judicial system. Enhanced scrutiny and promotion. The direction to introduce a suitability test for promotion based on merit cum seniority is a crucial development. By incorporating criteria such as the quality of judgments, legal knowledge and viva voce performance, the court aims to ensure that promotions are based on competence, not just the passage of time. Passage of time may be a good word it's trying to use in replacement of seniority. Emphasis on practical experience. The restoration of the 3-year advocate practice requirement for candidates applying for the post of civil judge is a critical move to ensure that new judges have foundational, real-world legal experience. This can lead to more practical and effective judicial service from the ground up. Now, potential criticism is also there. Impact on seniority. Obviously, seniors would feel that, right? While the increased LDC quota promotes merit, it fundamentally alters the existing promotion structure. This could lead to discontent among senior judicial officers who are on the seniority-based promotion track, as their path to becoming a district judge might be delayed. Subjectivity of the suitability test, because viva voce is always subjective, it can be administrative burden. That's not a crucial criticism. Inclusion of all experience. While the judgment restores the 3-year practice rule, it might not fully account for diverse legal experience. The document mentions considering experience as a law clerk but the primary direction focuses on advocate practice. Because the judgment says, even experience as a law clerk could be sufficient, but still it does not make it a rule that that experience can count in you becoming a civil judge. It says advocacy of 3 years is required. So criticism is what about the legal research clerks who are almost doing the same job in the chambers of the honorable judges except pleading in the courtrooms, right? That should be sufficient to give one an exposure to how courtrooms function. But that the judgment does not allow, though it talks about it. So very fine summarization has been given in this. There's not even a single mistake in this. So now I'll take out the main judgment, peruse it very fast, whether I can find any faults that this is saying. It shortens my time. I did not now go line by line unless the specific question or direction is from the honorable judge to look for. This is my summarization. I got to know the case in 5 minutes. I don't even need to read the whole judgment. So my demonstration, this is you can use AI. Okay? To the best of your ability, and but you need to, as the saying goes, separate the chaff from the grain. Broader topic at the top, I saw this. Duties and responsibilities of legal clerks come legal assistant in legal research. I don't know, someone said it's difficult to see. I'll try to increase the size of the page. Conduct, what's the duty? This is the basic one. Conduct case law research by locating and analyzing relevant judgments and precedents. Locating, as we saw, some said books, some said AI, some said Google. If you go to Google also, Google is also now giving answers somewhat in the form of AI only. But I would still prefer the AI tool rather than Google nowadays. Because Google is a much more bigger search engine and will have a tendency to give you more wrong results than the AI tool. Undertake statutory research, which we first talked about, including study of statutes, rules, notifications and amendments. And when it comes to Sikkim, a peculiar problem comes in with the judges, maybe with the readers also, that we have old laws, right? There are quite a lot. We are very much, how many old laws we all know by hand? Yes, come on. So it becomes quite peculiar. I think you also do that whenever legal research is being done, whether some local laws exist on that same point. Okay, otherwise, there might be a completely misleading in view of the fact that old laws are saved, and no matter what other laws are there, that the old law would be applicable instead of the law which you found. Perform doctrinal research through legal commentaries, that books, textbook, and scholarly articles. Scholarly articles you usually don't rely, it's the last form of interpretation, that it must have some value, like the on medical jurisprudence we have, what's the name? Modi's toxicology is a accepted book. Sometimes even that book is used to overturn the opinion of the experts, that those who have spoken in the court. It has such high value. But we reach there on this scholarly articles or books on a particular subject only in the end. That's the last form which we resort to. Carry out comparative research across jurisdictions when required. Especially, right, Honorable Judge too, who prefers reading the judgments of the foreign jurisdictions as well during his case laws. I have seen him doing that. So, carry out comparative research across jurisdictions. Most probably the English laws, English judgments would somehow, I do not know the reason why it exactly happens, does match to our situations quite a lot, even though their laws have changed, especially in writ matters where fundamental rights are involved. Update legal authorities to ensure reliance only on good law that has not been overruled, like what Madam Daphne pointed out. Yes, I agree with her when she says that the AI, does not mention that the particular judgment has been overruled. Because still, these AI tools are still not familiar with understanding what is this overruling legally, right? It has to develop more. It does not understand overruling. No one has taught these machines how judgments are overruled. Sometimes by majority, sometimes by per incurium. There are so many ways the judgment is overruled, right? Sometimes by larger bench, the AI tool still does not understand that. That's why I said the particular legal AI tool is required, which has been taught what is meant by overruling. Prepare case briefs, sometimes you will have to do this, digest and head notes for judges. Draft notes, legal memoranda and research papers based on findings. Format and reference documents using proper legal citation stats. Now in this legal citation, how many of you are familiar with neutral citations? One, two, yes. Whom should I ask? Daphne, yeah, sorry. Darsana, you did not raise yet. What is neutral citation? Try one. Okay, Nihal, neutral citation. I told you almost that.
Sir, as per my understanding, neutral citations are those citations which can be found in AIR, SCC or any other, sir.
Which can be found means?
So, like AIR, SCC or any other, sir. Like Indian Kanun, sir.
I know. It's alright. Oh, yes. Yes, Basant also did not raise his hand.
I believe is that the citation which is generated by the court system itself, which is along with the barcode and all.
Yeah, but what is it? Why you? Yes, obviously the computer generates this. The CIS generates this. This is our neutral citation, 2024 SHG 14. So this neutral citation is let Sonu answer.
So this help of this citation, the judgments can be reviewed by the entire world.
No, AI also can be viewed by entire world. What's that?
But I think it is much easier than this SSC citation.
Easier? How is it? Easier banale?
Because it directly takes us to the website of that court, which passed the judgment.
Okay. Yes, definitely. Your view? What's neutral citation?
Neutral citation is a citation like we have SSC online, Manupatra. They give a different, the same citation does not appear in SSC online. It's different in Manupatra as well as in AI online. And Indian Kanun, I don't think it's an accepted citation.
Indian Kanun,
yes.
But sometimes you get some judgments which you do not find anywhere in Indian Kanun.
Yes.
But its page is so poor one web page that if you copy it, it's so difficult to paste in the.
Sometimes the paragraphs are also not mentioned in the original judgment, but then it appears in the Indian Kanun.
So yes, she's correct that it's the neutral citation is a citation developed by the Honorable Supreme Court, especially by the E Committee. That it's just like she said, AIR 1976 SC24 SCC citation. No, the piece is okay. 2 SCC. How does it run? Boston SCC citation it has a formula, right?
2012 SCC 3001.
Okay. Brackets.
This is practice.
Okay. So it's a different one, right? Though the same judgment may be there, but both refers to different lists. Some prefer AIR to cite, some people prefer SCC to cite. Only these two are cited commonly, right? There are no others. So and one of the biggest thing is, you can't see this AIR or SCC judgments without spending some money. Can you see? For free. You cannot see. Another thing is, it's a third party compiled judgments. It's a publishing house, right? As she pointed out, that we can go directly to this website. In fact, even the scan barcode out there, QR code, sorry, it takes you directly to the judgment. Even if you print this page and scan it, it takes you to the High Court website. Authenticity is 99%. 1% of someone phishing the website is always possible in technology, but 99% you reach the correct source. Okay. So neutral citation 2024 is the year. SHG Sikkim High Court 14 is the case number. Is the 14th case, and it goes serially in the year. Okay, this is the 14th judgment that has been delivered in that particular 2024 year. Okay, so First benefit is, you don't have to spend money. You can go to any High Court's website and search. We have a citation search through neutral citation as well in our website. All High Court websites have. Another thing is, the authenticity is much more clear. It has the original judgment that is there in the website instead of being, compiled and printed somewhere which may have a mistake. Another thing is uniformity. Right? You need not cite some citing on the same judgment. The two lawyers on the same case may cite differently in the two documents. Some might cite through SCC or some through AIR, right? And monopoly. Only, as I said, only these two. Why we are accepting only these two publishers' citations? Because we have no options. So now this one is free of cost, and as though it's not very popular as of now, I do not know how will it be popular. Still AIR and SCC is preferred because they have extensive judgments, So, but that is the purpose of neutral citation. So if the honorable judges are familiar with this, you may cite neutral citation while making your reference documents. Administrative and support functions maintain legal databases, case law indexes and citation banks. So this is usually done by the library. Coordinate with libraries, archives and digital legal resources. Provide clerical and secretarial support such as scheduling, typing and proofreading. Ethical, you have a very ethical role to play. You would be knowing what judgment is being pronounced. Sometimes the cases are very sensitive. You might, as a human, you might get a tendency to tell your closest friend this is happening in the court, right? Secrecy. So you are to maintain secrecy of what judgment is being drafted there and what is being pronounced. And mind you, there will be many people trying to know it. Our High Court is small, so not many people come there. But if we as trial court judges, many people from the inside only want to know what is the outcome of the judgment going to be, so that he can, I'm quite poor in idioms, so that he can get some kind of benefit from the person to whom he is informing. Especially it happens in political cases. I have experienced it. They will not ask you what is being, what is the judgment being pronounced. Will it be pronounced today? They are trying to know, how my judgment was tried to, the accused was not coming. I fixed the case for pronouncement of judgment. The accused was seeking adjournment. I was granting it. And then someone would come to me from inside only and say that, so will you pronounce in his absence or should he come? The moment I say, I can pronounce in his absence, it means acquittal, 100%. The moment I say, no, I cannot pronounce, it is conviction because the person has to be there on the day I am convicting. Okay. No, I can't say that. If he is asking for adjournment, he can take it. So at last the person had to come. And with all that, though it's not some kind of a suspense or something like thriller or judgments, but you can't leak it before it is pronounced. So confidentiality, ensure accuracy and thoroughness in legal research with proper citations, which we said that, which we discussed also. She said the AI would be giving wrong. We have to be very accurate. Cannot rely completely on it. Uphold neutrality and impartiality while assisting in legal matters. Now this is also very important because you as a person may be having a certain view in a case. Though you are not a judge, but obviously it will influence you. Why this is being, some indirectly may be affecting you in a larger sense in some writ petitions, right? So you need not be prejudiced. You have to just use your brain and assist it. Okay, you have to keep your personal views aside. If that creeps in, then that may be considered if something happens as someone trying to influence the judge. So just be clear about that, okay? Uphold neutrality, and this is the same one. Demonstrate integrity, honesty and diligence in all assigned tasks. Integrity, as I said, you have to be very confidential, honest. There's no replacement for being honest in this world. So that's all I have for today. Now, as in the initial, Kamal was mentioning something about, because it is got related to computers, that's why I'm asking him, regarding that limitation and filing. What you were saying, from the day of something you were saying, and sir said there is a notification. Sir said there is a standing order which says that, unless the defects are rectified, the period doesn't run. So you meant that, right? The period doesn't stop. Yes. Oh no, it stops. You cannot extend it. So I meant that.
So actually, as per the requirement of law, sir, the limitation when a petition or appeal is filed before the High Court, the limitation has to stop on the day it is filed, irrespective of whether it is defective or not. So,
no, sir said there is a standing order against what you are saying. So what do you have to say on that?
There was one order of the Honorable High Court, sir, on the judicial side, sir, which directed that the limitation, unless and until defects are cured, the limitation will continue to run. So that it will not stop on the day of filing, but it will stop only on the day the defects are cured. But that judgment has been overruled, sir. That ruling was later on overruled by division bench. Sir. I think a bench of 3 judges. Sir. Once
I what 3 bench judgment I remember of one on 164 CRPC, and the latest one, though not a 3-judge bench, but the honorable, the 3rd judge.
So once the 3-judge bench has sat in the
okay, in any case, whatever it is, the problem with now is that there is a registration process in computers. The moment the case is filed, a filing is registered. Case is still not registered unless the defects are cured, right? So this has been a problem there, because once you file, because even I am, I feel that only when the defects are cured. It's not that only when the defects are cured that the limitations will stop, because once you file a case, you're filing it responsibly. Otherwise, I've seen that in enact matters in the trial courts. Enact is very specific about timeline, about the notice at what point of time being given. What the lawyers would do is, they would just file 2-page petition without even the documents, and the filing counter was accepting it just to avoid limitation because the case is filed. Now when it comes to the judge, once it's filed, it obviously gets registered and comes to the judge. When it comes to the judge, I see the filing is within time. But there are no documents supporting those pleadings, which ought to have been part of original filing. So this is how they could bypass this. Stop the limitation, I can bring my document at my own sweet will. So I think my personal view is, once it is filed, limitations should stop there despite defects. Otherwise, I can cure defects. 40 days is the High Court which timeline it prescribes. So I get 40 days extra to do what I ought to have been done to that deliberately.
I don't think this practice and procedure rules of High Court has clarified that provision, and ultimately, if that particular judgment is overruled while in court, otherwise, if there is inconsistency between the judgment and the provision of the Limitation Act, then obviously we have to see the Limitation Act. Limitation Act, but the problem here now, just CPC pointed out, just to purchase, just to
block the limitation.
It is the duty now, filing center. Here the problem in our judiciary is there. So, even with all respect, even the stenographer, they are not having law background, even the police officer. So therefore, we are now posting those employees in the filing center who are not having law background. So we keep on insisting, based on experience only, to perform their duty. So the administrator, the head of the institution, should apply mind to ADM, or the district judiciary, or the registrar, who is competent to, who is well versed in this particular statutory provision, should be kept in the filing center. Then he can verify the pleadings.
Yes.
Then properly stop this particular practice.
Yes.
Otherwise,
Because I, as a lawyer, if today night I remember tomorrow is my last limitation day, I realize it. I will sit for about 3 or 4 hours, prepare a basic memo of appeal, and then file it. And as per High Court, what's the 40 days, right? 40 days I have long time to amend it. Actually, I'll be not curing the defect. I'll be amending my petition without going through the process of law. This is I don't know. These issues has to be brought by concerned section, so that a thought comes on. It goes to the honorable judges, and then this I have felt it in an act. I have always received cases which is incomplete, but filing date is logged in the computer. Limitation, they are saved, and they come very slowly with the documents, filing applications, and kindly allow us to file documents and all, bypassing law differently. So that's why when Sir pointed out and that 40 days also the practice which I told once I was to the judicial section, I was in charge of the registry during the winter vacation. A certain advocate, what was the application? Pleading for condonation of delay, though the word used is not correct, to the registry that I filed it late, kindly accept it. And there is a provision, that day I knew there is a provision in PP rules which allows the registrar the power to accept the petitions beyond that date after curing of defect. And what was the practice was the registry was giving a total of 40 days at once. Well, as the rule says, registrar is at discretion to allow. If the defect is just changing one sentence, I will only give 2 days. Why do I need to give the person 40 days to correct 2 lines? That's absolutely in the discretion of the registrar. But the practice that is going on is the lawyer is given first 20 days, and then next 20 days is invariably extended by the registry routinely. So the lawyers every time are coming on the 40th day only, because they know that there is going to be an extension on 20 days also. 1 or 2 cases, no registrar would like to stop a case on that ground only. Obviously they will allow its filing up to 40 days. But how much time is to be given? A bigger defect requires a bigger time, smaller defect requires a smaller time. So I had wrote this in file only, that was my job. Next, nothing happened on that. That was now, my role is over. But I have quoted in the file that this practice is wrong. Because I could not stop. That a lawyer had come very late. I, as a registrar in charge, had the power to stop filing. I couldn't stop because the legal process was not followed. How can I take advantage of registry's own fault and stop the filing? So we were incorrect, so we could not stop. So that is how the things are going on. This particularly, without any feeling to anyone, particularly who heads the judicial section, practically is the joint registrar. The registrar sits in the office and looks overall, but the small things are not known to the registrar, and the files are also not put up there. It ought to go to the registrar. If the registrar is confused, would not be able to do it, would put it up to Registrar General. Still the confusion arises, it goes to the Honorable the Chief Justice. So things need to improve actually.
That the copy of judgment, there is no such definition of urgent matter, but it is the parties bring to the court an application either in the form of mention memo.
They will always write urgent.
Yes, sir.
That's why they are coming.
Urgent listing of the case, or they can even file, as per PP, they can even file an application for urgent hearing of the case. But urgency is the purely up to the parties to.
No. As a joint registrar, how you determine whether claiming the contents as urgent? How you determine as an official of the registry whether this is urgent matter or not?
That the facts and circumstances of the case have also to be taken into account.
Yes, but at one point of time when I was on duty, I was put up a file saying the counsels are filing this case as an urgent matter. Okay, the file said only that much. The file that came to me from an officer immediately below me in the registry did not say whether it's urgent or not, did not have his or her view. Then I sat over it. When I read it, it was absolutely not urgent. So there was 2 courts available to me. So I said the particular officer, I'm not named, call the lawyer to me. So lawyer, after about 2 days Sikkim. It was very much evident that it was a tax appeal matter, I guess. So when I read, it was not absolutely urgent. They were seeking a stay of the matter, in which stay can't be granted at all in performing a statutory duty by an income tax authority. No stay can be granted over it. Law is so clear on that. So when I called the lawyer, I pointed out to him the law says that. I did not say I know more than you. I said I pointed out the law says this. What do you have to say? Do you still consider it urgent? So after about 2 or 3 discussions, that very same day, the lawyer agreed. Okay, it's not urgent. We are withdrawing that urgent application. So things got handled there. Now I may not have the power to decide whether it's an urgent or not, but the lawyer got convinced and withdrew. Even if he would have persisted, I would have gone to the honorable judge, written on the file, this is the facts, these are the cases. In my view, it does not appear to be urgent. However, it's lordship's discretion to consider. But I had to summarize the case and give it to you. So that was another course available, because I don't think that even if the lawyer is insisting, no, this is urgent, please leave the court, I can on my own reject this as not being urgent, unless it's palpably not urgent and a frivolous petition has been filed. So, but what my point is, the section, the immediate below officer from whom the file came to me had no opinion on it. Only the lawyer mentions it's urgent. That is so burdensome for me sitting there doing. I was not just dealing with cases, I was dealing with files of all these sections. It may be genuinely urgent. So a little bit of, some effort from this section would help at the top a lot.
Sir, but if we start, just one.
Yes.
If we start determining whether it is urgent,
No.
then the parties will say, the courts will say that the registry, there is another court sitting there.
Now if you want me to spill the beans here, I should not actually. We can talk one-on-one inside the room. But I know he never gets convinced. And ultimately I'll have to give up. It's not only me, it's every officer. Kamal is something extraordinary. So I can spill the beans all here. We can discuss that later on.
Yes.
And no steps were taken after that also, in the actual process that ought to go on, where I pointed out 40 days is not the mandatory period that the registrar has to grant. You can start with 1 day also. But there's a practice of exhausting all the 40 days by lawyers in curing the defect. It was so surprising. You have to be sweet at some times, but not every time to everyone. When the rules are clear, one has to be firm in the registry. And another thing I found in the judicial section, which Madam knows, is that there are chronic litigants who comes to High Court and would threaten the judicial section staff to complain to the Honorable Chief Justices. Once she said me, they were not complaining. It was something that ought to have been told to the registrar immediately. But one fine day when I was checking the Xerox machines in the judicial section, they ventilated their problems in this section. So there I found that one particular litigant would come to the judicial section, would ask for certified copies of huge volumes of document. Once it's complete, doesn't take it. And even if he's willing to take it, he doesn't want to pay the money. So, and they said he used to threaten the staff with saying, I'll complain to the Chief Justice. I simply told them, let him go and complain. If you are not at wrong, you point out what he has done, he would never go outside either. So there's no need to fear if you are right. If there is some confusion coming on, you can always visit your registrar or registrar general and say this is going on, instead of living in that fear. And the solution, I pointed out the problem, it was for the registry to take out why so many people, even after wasting so much of pages, still lies there in the judicial section, certified copies which they applied it but never took it. Okay, so those are the problems that you will need to point out to the registrar, and the solution is obviously that we can make a rule which says unless taken within this date, we will not give it again, and the person will be blacklisted from asking again if it's a repeated offender of that kind. So I think there are lots of problems in these sections which you will need to discuss. Of course, all can't be solved. I even know the problem there is that there are no sufficient rooms for the officers or even for the staffs. We have such a huge increase in the employment and the staff who have come. The translators, I know they are staying in a very small room, but I can't do much about it. The only hope that I have is a new building is coming out here. and we'll have sufficient space in the future. So some of these problems can be solved, but people not taking certified copies after applying. I've seen huge piles being lying there, wastage of paper, the resource, the human resource as well as financial resource. Nasir would know it, how much he photocopies the documents. So these are problems actually which can be solved, and it should be pointed out to the proper officer. Okay, I handle the computer section and I can point it and talk about the solution, but I would not like to move the files, even if I can, because that's not my job. I'm not shirking away from responsibilities, but I have a particular line of working there. No? Every section has their particular line. Another thing I want to say to my staff is that the computer is not just a computer section. As the things are growing now, everybody has a computer. So small faults, need not be pointed out to the computer. In fact, a few days back there was a problem in the court number 1 regarding use of mouse, in which again Mr. Kamal was involved, not blaming you. So we are having a very comprehensive training, probably in the academy, for all officers from AR and above, assistant registrar and above, including readers and all. We'll be teaching basic troubleshooting and all. I have had an experience where the screen went into sleep mode because it was not used for quite a time in the courtroom. And why it got dark, no one knew it. A simple press of one button in the computer would have again bring the screen to life. And for this, if we are to be blamed, that's really disheartening. That's something wrong. Nothing is wrong with the computer. I even know a instance where the printer was actually not switched on. And when you give a command to print, it did not print. There's no fault with the printer. The thing was the printer switch. Electric switch was not switched on. So, these things, it's to be really handled at that level only. Now, more than that you should be able to handle, especially the readers, the Zoom applications and all. When we sit for online trainings and all, we handle those Zooms ourselves. Even we did not know. Zoom came in, it was there maybe, but we knew about it only during COVID. And so on and so forth. So, I request you all that some of the basic things can regarding computers can be handled at that level only. Inserting jacks and all, switching it on. Switching off the computer is very important, Even in my chamber, sometimes I switch off the computer. I can switch it off. But everybody have the task divided, right? I may be called into the chambers of honorable judges or by the registrar general, senior officer to me. I may go there. Some discussions may take place, or sometimes even casual talks take place. I will not deny that. I may not go back to my chamber. Should I go and check? I even close the windows of my rooms when I'm exiting earlier from there. But if somehow I do not close it, the concerned person should do it themselves. That is their duty to see that. So I find in the courtrooms and even in offices, the computers are not switched off before that particular person using it is leaving. Is it the job of chowkidar? I do not. I would say no. It's not the job of the peon also to shut down the computers of everyone. Mind you, it's a personal computer. These computers which we are using is known as personal computers. It's yours. No one should touch it. So kindly shut down the computers, and once you do that, kindly shut down the UPS also. That's still on. And once you shut down the UPS, shut down that switch also, because if there is a lightning and all, there's going to be a huge damage to the computers. And then the computers which we are giving now are quite costly ones. Difficult to replace. So kindly see to that's very easy, just shut down. And the computers which we have given have fast processors. So it shuts down quite early also, except the old ones. So that much can be done. In fact, light also can be switched off who is exiting the bus. So these are as we were talking about etiquettes today morning, these are the basic office etiquettes that one needs to learn. But there is a routine robotic type of working. In our phase 2 building, the light is so sufficient sunlight that we don't need lights. Every time I'm pointing out, we don't need all these lights in the corridor, 1 or 2 is sufficient, but they work so routinely, the chowkidars, they have to switch it on. the entire lights. It's not required also. But they have been groomed in that way, they have been tuned in that way, that automatically they have that muscle memory of switching it on. And every time I have to switch it. They see it, but still don't realize. We have this problem in the High Court of not rectifying the mistakes, or what has been told is they understand it absolutely differently. Instruction एउटा हुन्छ उनीहरूले अर्कै बुझिदिरहेको हुन्छ, and when you point out later on they said you said it, but I never meant that, I or we, whatever. So there is this, I don't know, lack of training also. In fact, last time there was an appointment of driver in academy. What thought came in my mind was the new drivers who appointed, after about 1 month they are spoiled by the old drivers, because the old ones know how to check out from certain places, because drivers are the one who are most worked. Believe me, they cannot leave their offices. If the officer stays till 9, they'll have to stay back. If the officer goes home, they have to go. So they'll always find a way out to what could be the excuses they can make in that formal official setting. So I thought that, I was thinking of sharing with learned director also, the new drivers has to be some kind of, orientation program, so that they don't learn the wrong ways from the old staffs.
Last time.
So that's all from my side. Thank you.
Yes.
Its use for any other form of web searching except the essential ones. And if you are using a different computer to write draft certain judgments or all sometimes, then it will be better if there's no internet connection in it. We had visited Singapore on the ECOS project. Ministry of Technology, a particular room had no internet. People thought that there's no internet in Singapore, but actually they deliberately, there was no internet in that floor because of security reasons. The moment you don't have internet, there is no data transfer. So we can think about this. If you all feel that you need a certain computer where internet connection should not be there, we are willing to give it. We are willing to. We have a lot of computers.
That will be of great help.
I don't want to disclose how many I have, because people again come again and again saying that I need one computer, though they have very new computers. So yes, you all can talk about it yourselves and where you will place that. Okay, there you can work your confidential things. Rest, digital hygiene is how you browse. Don't click links which are not known. Emails might come, especially to the honorable judges. Emails might come. Some phishing emails with malware and all, those are very dangerous. So these things cannot be stopped completely also, though we have central antivirus in the High Court. It will protect to a certain extent, but some attackers are very, very shrewd ones which no one can stop. So digital hygiene, as we all know, no need to do what is not required to do in the mobile phones or computers. Once you stop doing that, you are 90% secured. And people have that feeling, my data will be, it's not easy to hack, okay? Unless they use you somewhere. They will use the person, the owner of the device, somewhere to do something wrong to hack. Otherwise, it's very, very difficult to just get in and do it. They will use you. So be suspicious of what things come. Like, all may be doing online shopping from the same computers as well. And mind you one thing, the computer section can see, well, not virtually, but where everyone is visiting, okay? The day might come, we do not know. The administrative authority, competent authority might say that, have an audit of all those websites or whatever is being visited in the office. So we can still take out the data. So don't do unwanted things in the computers. Shopping, of course, you can do it. I'm not saying don't do it, but don't make it your private computer to do these things. That's how the viruses come in. Where there is internet, virus will definitely come. In fact, I have noticed that some of the staffs are carrying virus in their pen drives, because they are using that everywhere. We have had that experience in the past. And we ultimately traced one staff who had a virus in that pen drive, and it was being spread everywhere because it was used officially, but other certain documents which was downloaded even official documents that were downloaded, and one had come from Home Department. A gazette was bought in that, and he bought a lot of virus to our office. We noticed it only when, few of the computers started showing similar problems, including mine. So when we found out, then when we traced it, that the last known source of that pen drive was Home Department, Government of Sikkim. So compared to the other departments, we are very much secure on security in the High Court. But still, we cannot say there cannot be any data leaks from there or some kind of other attacks in the computers. We cannot ensure 100% safety. So it's upon us to be, digitally hygiene. That's all from my side. Thank you very much. I pass it on to the learned today.